Today's topic involves the Fifth and Sixth Amendments, things to consider when questioning individuals who have pending criminal charges and therefore may be represented by defense attorneys. I'm Steve Serbalik, and I'm a panel attorney with ASCOPS in Arizona. Here's the scenario. You're investigating a homicide and your primary suspect is in custody. 3 months ago, he was arrested and charged with 2 counts of residential burglary for properties on the other side of town. But his trial for those charges hasn't happened yet. After you arrested the suspect tonight, the suspect's parents call his defense attorney. You talk to the defense attorney over the phone, and the defense attorney tells you that he's representing the client regarding the residential burglary charges and any other pending matters. And the attorney says that you can't ask the suspect any questions about tonight's homicide case without the defense attorney present. After talking to the attorney, you hang up the phone, read the suspect his Miranda rights, the suspect waives his Fifth Amendment rights, and you question the suspect only about tonight's homicide. Did you break the law? The answer is no. There are 2 different constitutional rights at play here. The Fifth Amendment right against self-incrimination and the Sixth Amendment right to counsel when faced with criminal charges. I'll talk about the Sixth Amendment right first. The Sixth Amendment's right to counsel attaches or applies once criminal charges are actually filed. In the scenario that I gave, because the suspect has already been charged with those residential burglary counts and has a lawyer, questioning the suspect about the crimes for which he was charged and is represented would violate the suspect's Sixth Amendment rights. Sixth Amendment rights can be invoked by both the suspect and the lawyer. So because the lawyer advised you that the suspect was represented and that charges were pending regarding the residential burglaries, you as a police officer can't ask any questions about the circumstances behind those charges without the lawyer present. But what we really care about here is today's homicide case. And because the suspect wasn't charged yet, the Sixth Amendment doesn't apply. Quick side note here, the Sixth Amendment can attach to uncharged crimes if they're intertwined with charged crimes, meaning that they arise out of the same facts and circumstances as the charged crimes. But this intertwined issue doesn't exist in our homicide case because the prior residential burglaries have nothing to do with tonight's homicide. So moving on, what about the Fifth Amendment? That definitely does apply to uncharged crimes. Even though the Fifth Amendment applies to this circumstance, remember, you read the suspect Miranda, and the suspect waived his Fifth Amendment right to remain silent, and he voluntarily answered your questions. Unlike the Sixth Amendment, which a lawyer can invoke on behalf of his client for matters involving actual pending charges, the Fifth Amendment can be waived by the suspect regardless of what the defense attorney requests. So as long as the officers properly advised the suspect of his rights with the Miranda warning and the interview is voluntary, officers can proceed with the interview about the new case only as long as they don't ask questions about the residential burglaries. In other words, the suspect can talk to the police about the homicide case even if his lawyer doesn't want him to cooperate. If you have questions or comments about questioning career criminals and the impact of the Fifth and Sixth Amendments, please feel free to leave them in the comment section. And if you found this video helpful, please hit the like button below and subscribe for more law enforcement lessons. Videos come out every Sunday at 5:30 p.m. Arizona time. I'm Steve Serbalik. Thanks for watching. Stay safe out there.